Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Taman.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers with your hosts, Ben Siders, that's me, and the other guy is Kirk Taman.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders. You can find Kirk at KirkDMN, and you can find this podcast at LGGPod. Or maybe it's LGG Podcast. One of the two. You'll find us. Our website has unfortunately disappeared.
Yes.
We'll get into that in a second. But the important thing is that we're back after a lengthy absence. Not that we didn't record things. We just recorded things that we couldn't put out for various reasons.
Yeah, or didn't want to,
Or
and
want
sort
to.
of various things along those lines. You know, one of them didn't sound that good. But yeah, I think the real thing is we're trying to be back. We want to try to put some content out. We have, I think, both in our independent travels here, bumped into fans recently, and we definitely want to appease you guys.
Yeah, so let's, let me start off with a little shout out to the Oklahoma Bar Association. They invited me down, to give a little talk about, what we're going to talk about today, fair use. And so thank you, Liz, for inviting me down. I had a good time there. And then today's the first day I've seen Kirk since April.
Yes, I have been gone for a month, partially on vacation and then partially thanks to, screwed up airline transits.
Yeah, Kirk emailed me about a week ago, and he's like, I'm stuck in Milan. And before I have even remarked that the word stuck deserves sarcasm quotes there, he's like, yeah, I know.
But the issue with it was I was truly stuck, thanks to both an airline strike and then a broken engine on the plane, which was trained to me repeatedly. I really commented when we got back, you have one of those, it's amazing how much you want to be back on American soil where you can at least look at a sign and understand the language that it's in.
That I get. So today we're going to talk about, so the Supreme Court ruled in the Andy Warhol case that we talked about last year. We threatened in that episode to discuss this further once the case came down.
Which we did.
It now has, and so we're going to talk about it. So if you don't know the facts of that case, we're not going to rehash them here. I will put a link in the show notes back to that episode. You can familiarize yourself with it. For present purposes, what you really need to know is that the court ruled that, what, Kirk? The Warhol rule?
The Warhol rule is done.
Oh, the Warhol rule has died. It's very sad.
So because you are Andy Warhol, it is transformative fair use is no longer the rule. They ruled on behalf of Goldsmith, the original photographer of Prince in this case. We have Andy Warhol losing.
Yes, split decision. We have a 6-justice majority with Mr. Justice Gorsuch concurring, and then I think a 2-justice minority with, was it Sotomayor or Kagan on the other side?
I really can't remember.
I can't remember now.
Yes,
I think it was Kagan and Roberts were on the dissent. So I love the IP cases because when it's split, there's no political allegiance at all. You get weird configurations of justices, and that's what we've got here, which are always delightful.
Yeah, well, one of the things I think the IP cases are really useful for is they actually show you where the justices fall on sort of legal topics.
Yeah.
Because there's really no political grounds in them. And this one in particular.
Yeah, I mean, fair use is perhaps one of the most apolitical issues there is, and it often just boils down to kind of a gut check on how the justices feel about it. And this one, I mean, there's reasoning on both sides. The dissent is perhaps unusually vitriolic, maybe you'd say, for a Supreme Court opinion. But let's just get into it. Warhol lost. The sole issue before the court here was transformativeness.
And that's an important thing to keep in mind we want to talk about with this. We didn't necessarily get into it in our last episode, but we've noticed in commentary afterward, like people commentating about this, there's a lot of discussions of things like freedom of speech and artistic freedom.
Yes.
These were not things in front of the court.
Yeah.
The court here was looking at a very specific area of copyright law and one specific test under copyright law, which is normal for Supreme Court cases. Yeah. They tend to take these very, narrow legal views. But it's important because of the fact that a lot of when people are saying what the implications of this case are have nothing to do with the actual decision and what the court said.
Yeah, we should say that up front. There tends to be a very significant, I'm going to call it an overreaction, by both the legal community and the lay community to a case like this. Fair use cases famously tell us nothing about fair use. Not just at the Supreme Court level, but throughout. The circuits, the Second Circuit and the Ninth Circuit issue a lot of these cases. Other circuits cite to them a lot, but the predictive value of any fair use appellate decision, I would say, is generally limited, unless you have facts that are really, really, really similar. Yep. You often can't glean much from these that's generally applicable to other cases.
And again, I think it's to fall back, and I believe I mentioned this at the end of our last Warhol episode when we were talking about this. one of the things to me in this case is there is no right answer here. There was no clear area where you can say this is or is not copyright infringement. There were arguments on both sides. You also, we were talking about this earlier with Ben. One of the things I think that was interesting about this case, and I think part of the reason the Supreme Court took it, is because you don't have disparate sides. You have two artists against each other, both of whom are established, recognized artists against each other. It's not where we have somebody who's a world famous artist and a nobody. Yeah. We have two people who are both substantial.
Or like an artist that's like at war with a content platform or something like that. You have direct artist on artist violence here.
Yeah, and I think that that's very important because a lot of what you had is this is bad for artists. And the answer to it is which artists are we talking about? It's good for one of the artists. It's bad for one of the artists. Saying it's good or bad for artists, plural, doesn't really make any sense. And so, those are one of the things that I think is important to keep in mind with this. And what I think we want to try to do in discussion with this is a lot of the commentary on this, in my mind, has just been very reactive and very much of the, I think it should have gone the other way. And so therefore it's wrong. And look at all the reasons it's wrong. Had it have gone the other way, there would have been another group of people jumping out there and saying, this is wrong because it didn't agree with
This is going to be the death of art. The exact same arguments would have been made. This is the death of art as we know it. Nobody's ever going to make anything ever again because it's just going to get stolen. Instead of that, no one's going to make anything ever again because they're just going to get sued. It's the exact same problem.
And so, and I think that's important. And that's kind of where I want to start the discussion around this is we can't look at this and say, this is the death of art. We have to look at this and say, this is copyright law.
They said the same thing after Acuff Rose. There was all this commentary about how, all you got to do is say it's a parody. Now anybody can rip off anything. And yet, inexplicably, the music industry trotted onward,
Yeah, exactly. And is doing very well. Or at least reasonably well in the last few years.
Yeah. There's a Napster problem. That's a separate issue. Napster was definitely not a fair use. Let's go through the fair use factors real quick. For those of you who don't know these offhand, there's 4 factors defined in the Copyright Act that courts are supposed to look at when determining whether something is a fair use or not. They come from an original formulation put down by Mr. Justice Story in the early 1900s, maybe a long time ago. I think it involved the publication of General Washington's memoirs or something like that. I don't remember. I've never read the case, to be honest. But he laid out 3 factors to which Congress added a 4th in the 1976 Act, and they're all there in the statute. We'll go over them, but I'm just going to say they're not terribly illuminating. They give you some general guidelines, but when you look into the case law, no one factor is dispositive. It's not a situation where you just go through each one of the 4 and say for or against, and then total up which one wins. Like, it doesn't work that way. You can have 3 factors go against, 1 factor go in favor, but if in that particular case under those particular facts, that's the most important factor, it can outweigh the other 3. So it's we got a quote here in this, Kirk and I looking at a presentation my Oklahoma Bar Association presentation I just did. I pulled out a quote from a court. They described fair use as a doctrine that is so flexible as virtually to defy definition. And I argued to Oklahoma, I'm going to argue now that that's a feature, not a bug. And I don't know if this is true or not, but I have kind of a working theory that we should say the fair use doctrine doesn't really live in other countries the way it does here. Most countries either don't have fair use at all, or if they do, it is extremely circumscribed and limited, and the statute very well defines it. We're the weirdos, as usual, in the U.S., that have this largely unhelpful statutory framework under which sometimes you can do things and sometimes you can't. Nobody knows when. Is it a coincidence that American creative works have become very prominent globally when you have this flexible fair use doctrine that allows a lot more to be done?
Yeah. Well, I think some of it, quite frankly, as well. And I mean, as much as I'm going to say the two things are completely different, we do have the First Amendment to the Constitution and the idea that we look at it and say we want people to be speaking, which is in some sense a unique American invention. It definitely was when we wrote it. But it's one of those things where I think when you get into fair use of the copyright, we have this feeling that there needs to be an exception.
Yeah.
And that exception needs to be statutory. But at the same time, that exception can't be rigid. It can't just be these things are okay and these things are not.
And it can't be so broad that it swallows the rule, right? Although this is ultimately in service of the Constitution to promote the progress of science and arts. That's what we're here for. And so that's what fair use basically boils down to is the use you're making furthering what the Constitution says we have a copyright for? If it is, it's more likely to be okay. Not guaranteed, but more likely. And if it's not, then, you're you're in the crosshairs.
Yeah. And the other thing with it is, and again, I just kind of coming back to it, we have to keep in mind, this is copyright law. Copyright law is saying you can't make copies. That's what the copyright law says. It's illegal to make copies. It's a violation of copyright law to make copies without authorization.
Yeah. Every one of the rights ultimately boils down to, did you make a copy or not? No matter which one you allegedly infringe, that's going to be part of the analysis. Yeah. And we get the substantial similarities where you look and say, how close is it?
Yeah. And again, that's one of the things I think that the reason the court took this case, in my mind and looking at this, he unquestionably made a copy.
Yeah, that's impossible to deny.
It's really impossible to deny, which means we are solely in fair use. This is one of those cases where there's no other argument but fair use. And really the argument in here has to be transformative fair use because we have two artists against each other.
Yeah.
And again, I keep falling back on that. I keep mentioning it because I think it's really important to point out the fact that this case has very unique facts compared to a lot of fair use
So look
cases.
at the last one was Google v. Oracle, not artists. It was two giant companies duking it out. Before that, Orbison versus, it was Aka Froze really, but Roy Orbison's publisher versus Two Live Crew. Yeah. So you had a music publisher, a big organization versus artists. And what'd you have before that? The VCR case? It was Sony case. So we don't get a lot of these.
Yeah. And that's the thing with this is it's important for that reason. And again, I think that's part of the reason the court took this case.
And we should say two artists that do the same kind of thing.
Yeah.
Goldsmith was a renowned celebrity photographer. Like when you needed professional photography done of famous people, that's who you called in the 70s and 80s.
Yeah.
And then we have Andy Warhol, of course, speaks for himself. His reputation precedes him.
Yeah. And you'll have heard of Goldsmith, but I suspect you've probably seen their work. I mean, that's
for sure.
And so, that's the thing with the importance of this case. And so when we're really getting into this, we're getting into these transformative fair use factors. We're really getting into a case that has weighing. We are trying to look at it and say, we have a scale. We're going to stick some weights on both sides of the scale. Which way is that scale going to tip? And do we want to put our thumb on it and say it needs to go the other direction? Yeah. And that's what this case is.
We should mention at trial, Warhol won. They found it was a fair use because they said it was transformative. It went up to the Second Circuit, and they reversed. And I think some of the language in that opinion is why this went to the Supreme Court in the first place. Because talking to other IP lawyers, a lot of people have been like, why did this one get picked up of all the cases? Because they affirmed the Second Circuit. Did it really need the Supreme Court to also say, yeah, what they said is basically right?
Yeah.
But one of the reasons may be what you said. It's an unusual fact pattern. And there was some language in the Second Circuit decision that was maybe overstated what the rules were. But what's interesting is that both the Second Circuit and the Supreme Court tried to avoid getting into subjective assessments of the artistic merit of the two works.
Yeah. And that really is the huge thing here. And I think that's what people bump into. And that's our joke with the Warhol rule that we've made repeatedly in conjunction with this is it's easy to say Warhol has artistic merit because everybody agrees.
It's a Warhol.
It's a Warhol. But you also look at it and say Goldsmith also has artistic merit.
Yeah. And otherwise, why did Andy want to use her photos? Why not just use anybody's photos?
Yeah. And so it's those types of things where we have to get away from that artistic merit. And I think it's all too easy for commentators that are not used to looking at the IP law cases to look at it and say, but there's artistic merit. And the answer to it is we've got to not think about that.
Yeah.
And it's very, very hard to not think about that because it's Andy Warhol.
Well, it's also important with the Supreme Court in case in particular, these cases get appealed to the Supreme Court. The Supreme Court's not going to go back and Monday morning quarterback every last thing that happened. You have to write what the question of law is that you want them to address. And in this case, the Warhol Foundation, it was a very narrow question. Did the Second Circuit err in finding that his work was not transformative? He thought, or I should say his foundation thought, that the analytical framework that the Second Circuit used to conclude that it's not transformative was wrong. They didn't use the right law, and that was the sole issue up on appeal. So when I read these articles saying, why did they talk about First Amendment? Well, that wasn't part of the petition for cert, so why would they talk about it? It would be inappropriate to do that. On the flip side, the decision kind of punts some of this back to factor 4. We should talk about the factors. I keep threatening to do that, not doing it. Let's go through them real quick. So factor 1 of the 4 fair use factors is the purpose and character of the use. And including whether it's commercial or for nonprofit educational purposes. We often say that's kind of a weird false dichotomy because educational purposes can be profitable, and not necessarily non-commercial. But over time, especially after the Campbell versus Acuff Rose case, that's the Two Live Crew case. We did an episode on that too. Over time, there's been a sort of, I would say, perhaps overly fixated emphasis on the transformativeness of the use. And I think a lot of lawyers struggle with this. When we say transformative use, are we talking about, did you transform the original work into a new work? Like you made a lot of changes to it? Or are you saying the way that you used the new work is a transformative purpose?
Yep.
And it really involves both. And the Campbell Soup Warhol can, let me say it again. The Warhol Campbell Soup can is a good example of that. The new work is not transformative at all. It's identical. But the use of it is highly transformative. The soup can label is just to convey a commercial message, here be soup, versus Warhol is to kind of make fun of that and remark on it.
Well, and I think if you get into people like found art artisans,
Yeah.
now you're really talking, that's the idea, is it's saying, no, this is a completely utilitarian thing, but I have turned it into art by saying it is art. And so, okay, that's a completely different purpose, even though the work is not transformed at all.
Yeah,
it's
exact
literally
same thing.
identical thing. So, you get into those types of questions.
So the second factor is the nature of the copyrighted work. It's axiomatic amongst copyright lawyers that this almost never plays a meaningful role.
Yep.
We do see cases where it becomes more important, but if you look at fair use cases, there's very little correlation between this and the outcomes. And we see cases like Google v. Oracle where the court says, it's software, it's technology, it should have kind of a thin copyright. And then you see cases like basically everything else where they say it's a creative work that's entitled to the maximum amount of copyright protection. Nevertheless, it's fair use for whether it's, no matter how much protection it gets. So,
well, and I think the thing with the nature of the copyrighted work in some sense is we're getting at these things that say, do you have a really thin copyright or do you have a sort of standard copyright, for lack of a better term? I think you could say there's a thick copyright. I think you're either standard or you're thin. But where you're going to see that play into in some sense is that it's going to play into the purpose and character of the use, because it's, well, what's the use of the underlying work? If it's software, well, it has the utilitarian function. So did you alter its function? Did you alter, is it aesthetic? Things like that. Whereas, and I know when a lot of people talk about this, and I've even done it in conjunction with presentations when I do, Article 2 oftentimes just gets thrown into something else.
Yeah.
It ends up influencing something else. It's not really its own statutory factor.
I think there's an argument you could make that this should get more prominence. Kirk and I were talking earlier about how I'm kind of developing a theory of copyright where this should be more prominent in that where the vocabulary of expression for the type of work is more limited, especially if it's limited by nature, then that should play in here to where there's only so many ways to express yourself. Like music, for example, there's only so many tones that a human being can hear. There's only so many ways to combine them, and that's not jarring and offensive. So, particularly when you're limited by, say, Western music, you've got 12 notes to play with. Okay, there's only so much you can do. In commercial music anyway. So that probably deserves more prominence than it gets. But we see in reality, it basically falls out of the analysis and virtually never plays any meaningful role. The third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. In practice, courts tend to tie this back to the first factor and say, did you take no more than you reasonably need for the purpose you're using it for? So now we're back to the purpose and character of the use. It kind of falls back into that. So if your purpose is, like I said, Andy Warhol, a Campbell soup can, well, the purpose is to mock commercialism by just displaying the soup can as like framed art, like mocking consumerism. Okay, well then he used all of it. All right? But since you need to use all of it for the purpose, that's fine.
And I think the thing you really, quite frankly, I think with the third factor, what you really get into is a lot of the stuff with things like movie reviews. What we clearly say are fair use and kind of long been accepted, they fall under fair use because they fall under 3. If I've got a movie review and I show a single still frame from a movie, I really haven't copied any of it. That's the reality. And so I think it's, in my mind, 3 exists because it made sense of what had already been found to be fair use and was unquestionably fair use, not because it really matters in the future cases, so to speak.
Yeah, we see this also in other cases. I mean, there's plenty of fair use cases where they use the entire thing. It's nevertheless deemed a fair use. But it's a situation where, we're going to get to this in a second, basically the way you're using it, it's not a market substitute for the original. So like the Ariba case involving thumbnail images. Okay, well, it shrunk down so much that you can't use the thumbnail as a substitute for the original. So it doesn't matter that you took all of it and used it. It's still not a market substitute under Factor 4, so this falls out of the analysis.
And that is Factor 4, is the effect of the use upon the market or potential market for the value of the copyrighted work.
Yes. This is, again, axiomatic amongst copyright lawyers. This is by far the most important factor. You will even see courts say that. Everybody knows this is the most important factor because it goes back to the Constitution. We're trying to promote the progress in science, progress of science and the arts. And so if you are basically releasing something that people are going to buy that instead of the original, well, then that's bad because then people will stop making originals. That said, There are times where the effect on the market is fine. In the case of commentary, criticism, parody, if you give such a devastating critique of something that nobody wants it, that's fine. That's the kind of thing we have copyright for, is to, that's advancing the progress of science and the arts, as opposed to, no, I'm just ripping off your thing so I can sell it and make money myself.
That's also then bumping into free speech, because now it's the idea that you're saying, I'm making a commentary on your thing.
Yes.
I'm not copying your thing. I'm making a commentary on your thing, which may or may not, my commentary may or may not really be copyrightable.
Yep.
But that's where you kind of get into some of these free speeches. And I think that's why free speech gets drug into this, is because we look at it and say, we're affecting the market. That is affecting the market, but it's also not affecting the market in the fact that I'm making a substitute. I'm affecting the market by commentary.
Yeah.
And so it's one of those things that you bump into. And I remember this is one of the questions, like when we talked about Napster sort of earlier, one of the questions with it is, well, don't I increase the market for it by increasing the music accessibility? Because if, by hearing the song on the radio, I want to buy the album. So if I can hear the song by downloading it on my computer, wouldn't I want to buy the album? And the answer to it is that's a legitimate argument, except it never happened.
Yeah.
And so it's one of those things where you look at it and say, yes, if that had happened, I think you would have had a legitimate argument to say, no, this is how people are listening to music now. And that's what you bump into with things like streaming services. This is not a question that's been resolved. But we can bump into it, look at it and say, what does it mean to say you're altering the potential market when you have a literal copy, being made? And that's what these things are. So I think, when you talk to attorneys universally, factors 1 and 4 are oftentimes said they're the only factors that matter.
And they tend to be tied together too, which is why it's a little odd that in the Warhol case, factor 4 was not up on cert, but factor 1 was, because they kind of play into each other.
Yep.
And that was basically the majority's ruling. They kind of looked at, this isn't quite how it's written, but this is how I read the case at least, and I know reasonable minds may differ here. But they kind of put this, I'm going to call it, there's the way that you transformed the original work, and then there's whether the purpose of the new work is transformative. So is the new work transformative, and is the use of the new work transformative? And here they basically said those are kind of on two different axes. And if the use of the new work is basically commercial and directly competitive with the original, well, then on the other axis, it better be really, really, really different. And they just said here, it's just not that different. Not different enough. And so they upheld the Second Circuit.
Yeah, and I think that's the thing with it is it's, when you really look at this, you have essentially artworks, competitive artworks, similar artworks, same subject matter, used in similar ways in some respects. I mean, they're both used in magazines and sort of stuff like that.
That was prominent in the decision. I think that's something that I didn't pay that much attention to when the case was first going up. I just kind of looked at these two images side by side, but they really emphasize that, look, Goldsmith makes a living off producing these photos and licensing them to magazines. And she's licensed a lot of them to magazines. And Condé Nast owned Vanity Fair. They licensed the original one.
Yeah.
And then the same organization licensed this one from Andy Warhol instead. It's a direct market substitute.
Yep. And again, that's kind of where I jump onto the fact of why this case has really interesting facts. And this case is a law school exam.
It is.
Like, it really is.
And Gorsuch really drives that home, where he says the exact same orange prints that was as issue here, stick it in a museum about art, maybe that's a fair use. Which goes to the point of, whether or not it's transformative in terms of how much it changes the original, you can overcome the fact that, according to the court, it's minimally transformative by making the use of it transformative. Put it in an art museum as opposed to on a magazine cover.
Yeah. And again, that now gets to the marketing issue with it, which is a magazine cover is how artists make money.
Yeah.
A museum generally is not.
Yep.
And so it's those kind of things where you really get into the factor 4 is now tangled up in factor 1.
Yeah.
Now, do we have factor 2 and 3? I don't think we really have factor 2 and 3 even discussed.
None of those. Yeah, they weren't up on certain. Not really an issue here. You could make an argument the amount taken is not. This is what I argued in Oklahoma. You could make an argument that what was taken by Warhol here is mostly the non-copyrightable elements in the first place. The appearance of prints is not copyrightable. It's just what the man looked like. That's just a fact. You can't own that. But I think if putting on my Goldsmith hat for a second, you'd argue she picked out the wardrobe, she styled his hair, she did the makeup, she did the lighting. All of those things affect what went into this photo. So how his eyes are shaded, how thick his goatee is, the shading of his neckline, all of that is a function of decisions she made when she posed and positioned prints for this photo. So I think even then you have a decent argument that there's still creative elements that are there and that were taken to use this, to produce the second photo.
Yeah. So then you can start getting into the nature of the work, you start getting into some of these other factors. And they all tie in again. Again, what we have to keep in mind is factor one is the only thing the court is looking at. What you really see is that their argument about factor one pulls in the other factors. Now, it strongly pulls in factor four.
Yep.
It arguably pulls in some of the other factors too, but there's a reason for that, and that's because they're all interrelated to each other and they can't avoid it.
Yeah.
But we're really talking about what is the purpose and nature of the work. And in this case, and to me, this is the kind of thing where I look at this case, and again, I was sort of doing my thing. I think this case was correctly decided under copyright law. I think there's a good argument that this is a problematic way to decide it. Though I would argue that the other side way is also problematic. But it's one of those things when you look at it and you say, what is the purpose and nature of the work? There is too much similarity here. When you're looking at it just those grounds, there is too much similarity here. There's no question it's based on the photograph. It's a literal print of the photograph. Mm-hmm. It's what it's both of them are magazine photos. Both of them are the same subject matter. Like, we have the same things constantly bumping into each other. So we say, what's the purpose and use? Is there really any different? And I think some of the commentators have kind of attacked that comment of if you put it in a museum, it would be different. But I think when you look at it from that legal point of view of what is it, he's saying that would at least give it some different purpose. There is really no different purpose here. Whether that would be decisive or not is up in the air, but at least it gives you something to argue is different. There's nothing different here other than he changed its colors.
Well, and compare that to some of the other famous fair use cases we've talked about. We've talked about the Gone with the Wind / Wind Done Gone case. Yep. If you don't remember Gone with the Wind, famous novel by Margaret Mead. And then we've got the Wind Done Gone, written by country music songwriter Alice Randall, another Nashville staple. But she rewrote Gone with the Wind from the point of view of Scarlett O'Hara's half-sister, half-sister, I think, who was also biracial, which under the norms of the South at the time made her a slave. Yeah. She rewrote the story from that woman's perspective, reusing basically the entire story, but the non-literal elements, right? She borrowed the story, the overall, narrative themes, but kind of rewrote everything from scratch, and it was a book, so it's in the same market, right? In theory. Yeah. But is it a market substitute? If you want Gone with the Wind, are you buying that book instead? Or vice versa? Probably not. If you want Gone with the Wind, you're buying Gone with the Wind because it's Gone with the Wind, right? Yeah. You don't just casually find Gone with the Wind in the bookstore and say, well, that sounds interesting. Either you've heard of it or you haven't. I think that's part of it. But this case kind of reconciles with that. Although it's in the same market, selling novels for recreational reading, arguably at least, it was highly transformative, right? Yeah. Because it was a complete rewrite of the story from scratch.
Yeah, and those are the kind of things that I think you really get into with this is that part of the thing, and I think you got to keep in mind, we are talking about IP, which means the court is not as into completely overturning itself as it sometimes is in other cases. They want to sort of stand on what they have. It wanted to reconcile this case with its prior stuff. And one of the things you really bump into in this is they've hung their hat on transformative a lot, that it is really transformative, that it's very different in some respect.
Yeah.
Using that, it's very different because it's a completely different novel, it's a completely different story. Yes, they're both novels, they're both books, but it's a completely different novel, it's a completely different story. It's not really a completely different artwork.
Yeah.
It's still somewhat similar, in the way that, it's not like he made a sculpture out of it. It's not like it's hanging in a museum. I can come up with arguments to say, here's things that I can at least say it was different. Like I said, in this one, the only thing I can really say is different is he changed the color. Now, it's a process, and obviously,
there's some styling in there. Yeah. Some of the lighting depth is different. But yeah, the biggest thing is the color.
Yeah. And so when you bump into it, you kind of look and say, what does this mean? Well, it's not really that transformative, is it?
That's kind of what the court said.
And it's kind of what the court said.
Yeah, not much.
And, that's when we're now getting into critiques of modern art, where I can look at it and say, it's a piece of blue paper hanging on the wall. Is it really modern art? Well, I don't think it is. Now we're getting into, artistic discussions and everything else.
We should also say that's something that we think the court was trying to avoid here.
Yes.
Because part of the Warhol Foundation's argument is that it was transformative because it conveys a different artistic message, even if the actual physical appearance is not that different. They argue that Goldsmith showed prints in 1981 when he was an emerging artist and he was vulnerable, and not weak, but, a little more insecure, a little more unsure of himself because he was early in his career. Whereas the Warhol image is showing him as a larger than life, iconic pop culture figure.
Post-Purple Rain.
Yeah, exactly. And I think the Second Circuit was like, look, we're not going to get in the business, neither judges nor juries should get into the business of crawling inside of the supposed infringer's head and asking those questions. And really, if that's the standard, then anybody can submit a sworn affidavit that says, my vision was different.
Yeah.
And looking at these, I don't know enough about art to tell you whether either one of those stands for the things that Warhol says it stands for. But that was kind of the core of the question, is that the Second Circuit basically disregarded that and said, okay, you can say that, Warhol Foundation, but it still isn't that different when we look at it, and it's for a competitive use, so it's not transformative enough. They said that was an error, and the Supreme Court kind of said, no, we're not going to try and guess these things and apply artistic judgments to this stuff. That's not a task for judges. It's not a task for juries. We need to have some kind of reasonably objective standard to tether our analysis to, and here's what it's going to be.
And that's my comment, is where I say I think it would have been bad for artists going the other direction. Because if the case would have gone the other direction, you could have exactly that. The argument is, I have an artistic vision. Now, I can make that artistic vision up, because you can't determine whether or not I really do. You can argue that my artistic vision is not good art. People have argued artistic visions are not good art for centuries, and then it's later found to be incredible art. That's the problem you get into, is you get into this thing where we start getting into the argument which says, if I say it's art, do I escape infringement?
Yeah.
And the answer to it is that that's a terrible standard, but that's kind of what going the other direction said.
Let's think about like Spaceballs, right? Like Spaceballs is clearly a spoof, right?
Yes.
It's a sci-fi spoof. Is it criticizing Star Wars though? Mm-hmm. Is it really criticizing it or parodying it, or is it more of a loving embrace of the silliness of the genre? I wouldn't say that's I've seen criticisms of Star Wars, like the Red Letter Media guys. They have criticisms of like the Phantom Menace.
Yeah.
They did an hour-long video criticizing it. It's definitely criticism, and they use a lot of footage from the DVDs, from the movie. Spaceballs doesn't use any footage of Star Wars, but it's really on the nose.
Yeah.
But it's a spoof movie, right? It's more satire than commentary or criticism. And a lot of these spoof movies are like that, where it's not really making fun of the original so much as it's sort of an approving nod, more homage, and just kind of enjoying how fun and silly these things can be.
And again, I think that's the one thing you really get into this, is it's, in some sense, I think the Warhol Foundation, in arguing this case, effectively was trying to argue Warhol was a visionary, therefore anything he did was transformative.
Yeah.
And while I get their point,
he was.
Yeah, he was. I also look at it and say the problem with that argument is we can't write the law for Andy Warhol or for anybody else. Because we could very well have an artist right now who is seen, whose work is seen as being terrible, as being dumb, and in 100 years we're all going to think it's the most transformative thing in the world, and they're the most important artist in the world.
The Great Gatsby.
The Great Gatsby was exactly where I was going.
Not well received in its time, and it really didn't get to be beloved until after World War II.
Yeah, and after his death. And there's huge amounts in conjunction with art like that. I mean, you really bump into these things where we say, we don't want to be making a decision that something isn't copyright infringement because I say it's art.
Yeah.
And that, I feel, was the most important thing in the presentation of this case that Andy Warhol Foundation made.
Otherwise, I can just go make my own Star Wars movie. I just stick an artist statement at the front that says, here's what my vision is. It's different.
It is art.
Okay, and then now what?
Yeah.
And now it's not infringement?
And how do you say, and then it comes in as, oh, well, but you're not a great movie maker. Oh, so now we're actually making decisions on who's a good and not artist. And so that we shouldn't
So if I was J.J. Abrams, then I get to infringe Star Wars without getting a license to it. Like,
even though he's the one who has the direct marketing and then the one who's directly competitive. And you can start to see how it becomes unworkable if it starts going the other direction. And that's the thing, I think, that when I looked at this case, to me, the reason I found it this way is because I really looked at it and said the alternative is we are making a statement about who is and is not a good artist. Yeah. That was really the problem with it. And again, sort of, I'm going to harp on why do I think they took this case? Part of the reason they took this case is because Goldsmith is a good artist. Like, we can't look at it and say there's only one artist in this. There are two.
Yeah.
And that's why you kind of look at it and say this case has good facts from that point of view, because we have something that says we can't say one of these artists is better than the other. We can say they have different visions, they have different styles.
Different levels of fame and notoriety. Yep. I'd never heard of Goldsmith before this case. I'm sure I've seen her work before.
Yeah.
I'd never heard of her. I researched her. I was like, holy cow, this person's extremely accomplished and was like a legend in her industry.
Yeah.
But just the nature of photography, how many famous photographers can you name?
Ansel Adams.
Ansel Adams.
We're all going to do it. It's good. we have to do that. But yeah, but that's exactly the thing with it is I think what we have is great in conjunction with this case is we look at it and say we have two artists that have one is well established and understood, one is well established but not as well understood. Mm-hmm. And what we really get into in conjunction with the court, and I think again where some of the commentators are missing it, is they're missing the fact that we have two artists. And we can't say this is negative to all artists because one artist without question benefited from
one
this.
Artist has to win and one artist has to lose. And, I think ultimately the court looks back at what the Constitution says and they say, look, if this is real simple, you should have paid Goldsmith a little bit of money here. Yeah. That's all there is to it. How much, that's up to the market to figure out. But, this is the argument I had with somebody about this, a couple weeks ago. The argument was made to me, look, what Condé Nast wanted was what Warhol brought to this photo, not what Goldsmith brought. If they wanted what Goldsmith brought, they would have just licensed her original.
Correct.
But, which is right. But then why did Andy use this specific photo? Why did he get the license for one and then go on and make 16 more? Yeah. Obviously something in this photo spoke to his artistic instincts. That's what Goldsmith brought to the table. If it wasn't, then why didn't he just use any old photo or hire an undergraduate student at his local art program to go just take a photo of Prince somewhere and use that as a reference photo? So there's something special about this photo that spoke to him as an artist. And when that's the case, I think it makes sense. The photographer deserves some kind of compensation. Maybe it's not more than Andy should get for this. I mean, his vision is what ultimately got on the magazine cover, but that's what the court was saying. Something. And the market can figure out what that's supposed to be.
Yeah, and I think that's the thing with it, where you kind of look at it and say, as an artist, you were influenced by something. There's one thing to say, I've been influenced by photography over the centuries. It's another thing to say I was influenced by this photograph to the extent that I copied it.
Yeah.
Those are very different things. And again, I think that's what the court is saying with this is you are what Andy Warhol brought to the table is the reason why Condé Nast chose this. But what Goldsmith brought to the table is the reason why Andy Warhol generated it in the first place. Yep. So Condé Nast wouldn't have gotten this image if it wasn't for Goldsmith.
Yeah. So let me throw something else out at you. I was brainstorming with some folks about, if you don't like the decision, how should this system work? Like, one of the things everybody loves and hates about fair use is that it's Olympic gymnastics. It's inherently subjective, yes, with a bunch of different people looking at it and evaluating things differly, which is what makes these cases fun to talk about. Because there's never a right answer. No matter what the answer was here, it was right? Yeah, but by the definition of our legal system, it's fine. How do you add predictability here? And one of the ideas that I've seen kicked around is, what if you introduce to basically any published work the same type of compulsory license system we use for music? So with music, once you've released a song to the public, anybody can go get a license to make their own cover of it. Now, the cover can only vary so much. You can't make like an entirely different style or song out of it, but there is still a lot of latitude you get there. And this has all been incorporated into the law. It's been there for 100 years now, more than that, 115 years. And it works pretty well, and it gives artists some compensation if people use their stuff. Could you implement a compulsory licensing system for basically anything that has been published to where somebody can go to the Copyright Office or whoever and submit the notice that they want to use it, and then we have basically a rate court type system like we do for music to figure out who gets how much for what's being used?
I think our one problem with that, I think it would be a great way to do it. The one problem I think you bump into with it is you start saying, well, it's literary work. Well, is the contract I wrote a literary work? Because it is under the contract, under the copyright law. But how do we deal with that being a mandatory license type of thing? Yep. You end up with sort of saying there's a level to it. The advantage of music is music has a certain level of what it just simply is.
It's a little more definable and identifiable. Yeah. And you're still going to have problems where people don't take the compulsory license because they think what they're going to do. We should mention this too. This the transformative fair use test, this is a derivative work problem. And the transformativeness test is not actually anywhere in the statute. We read what it says. It doesn't say anything about transformativeness in Factor 1. You know where they do mention transformativeness? Is in the derivative use right, which belongs exclusively to the copyright holder. So we got the Copyright Act says that only the copyright owner gets to decide who can make derivative works, such as works that transform the original. Then we've got this transformative fair use test that says, but then anybody who makes a transformative work, it's a fair use. No. And so that's part of what the majority pushed back on, is saying, look, there has to be a line here, and when in doubt, we kind of need to err on the side of derivative work because that's what the law actually says.
Yeah, we kind of want to err on the grounds of copyright holder. And again, that's where, when people jump up here and they're saying this is bad for artists, we're erring on the side of the copyright holder here. Like, artists are benefited by their copyrights. Now, yes, you can argue, hey, it's the music studios, it's the large thing behind it. That's an inherent, capitalist problem if you want to, argue about that. That has nothing to do with the law. The law basically says, in conjunction with this, we need the artist to hold their copyright because otherwise they have no incentive to generate the work.
Yep.
And, because that way they're compensated for it if somebody else takes it and tries to do something with it. And yeah, you kind of bump into that then practical reality if that's kind of what they did here.
Yeah. And if you have a compulsory licensing system, someone will just not take the license because they think they don't need it because their work is sufficiently transformative that it's a fair use or it's not even an infringement. We're so far away from the original that it's not even remotely close. And then you're going to get these lawsuits anyway. So even that doesn't fully solve the problem, although it would give you probably a more reasonable measure of damages. Although in this case, I want to say the license fee was like $10,000. How many millions do you think were spent on this lawsuit?
Well, and again, some of that I think was, quite frankly, artist versus artist.
Yeah.
I mean, and again, I keep jumping back to that. To me, that is, in many respects, to me, that is one of the most important facts of this case, is the fact that we actually have artist versus artist, as opposed to artist versus corporation, as opposed to, things like that, as opposed to artist versus unknown, unheralded person. Stuff like that. And it's not to say that, like, the corporation always wins or loses the case that they're involved with, but it's one of those things that I think oftentimes does play in.
Yeah.
The people look at it and they say, wait, the corporation has a lot of money into this. And that's, when you kind of get into that what's the competitive nature of the work, the more money you have in the work, the more likely you are to take some of the market for it.
Yeah.
And so you kind of get into that with the fair use standard already. This is a great one because we have artists, we have both artists doing commercial works for similar things, which makes it such an interesting factor. As I said, this is a law school exam case. Like if you were going to write a law school exam case,
it's a good one.
On fair use, this is a good one. And to me, that's part of the reason they took it, is because they really did want to clarify what is transformative fair use, and they did it in a case where they could. The problem with it is they also did it in a case where it's going to harm artists regardless. Now, arguably already had, because the Second Circuit was already law, but they had to harm somebody in conjunction with this, and they chose to do it in a way that basically said, look, this is what the copyright law is. You should have taken a license here. And we also have, in this case, commercial facts that said you could have.
Yeah.
And I also think that's a fact that influences them, especially when they not talk about it, is the fact that this was not something where he didn't think he needed the license, period, end of story, and just did it. He apparently thought he did, because he got one.
Yeah, in the first place.
In the first place. And so, why are you doing this? It smells of hubris, so to speak. In conjunction with it, you didn't do it because you knew it was great art and you thought you could get away with it. Whether or not that's true, whether or not that ever played into it, it's what it is. But it does kind of objectively from the outside, you kind of look at it and say, maybe it did. And again, I think that's an important sort of fact that played into the court here and where they went with it.
Definitely. Let's talk about what we're doing next. It's been a while, and we never did get the in-camera branch off the ground. That's in part because Kirk and I have not seen all the same shows at the same time, but I think we've gotten that now. So we're going to get the in-camera version of the podcast ramped up. There's also some logistical problems there. I learned, by the way, breaking news, we have to have 2 SoundCloud subscriptions for each podcast. You can't run 2 podcasts off one. So I got to get a second subscription set up there to host that stuff. We'll get all that done, but that's just one of the little inside baseball things that's kind of holding us up here. But Kirk has seen The Last of Us, the TV series.
So I binged watched The Last of Us flying to and from Europe. In the course of doing this, I made it through 5.5 episodes on the way there and all the rest of them on the way back.
We have spoken about this not at all, and Kirk is practically bouncing on his heels wanting to talk about it. So we're going to probably have that be our inaugural in-camera episode. We'll talk about that. We've also both seen Bad Batch Season 2. We're getting into Visions. And have you seen the rest of Mandalorian Season 3 yet?
I have not seen Mandalorian Season 3 because we keep trying to figure out which of my family wants to watch it and doesn't want to watch it or doesn't care to watch it. At some point, I'm just going to watch it.
Yeah. We got that. We've got Stranger Things Season 1 you've finally seen. So we got a lot we're going to talk about. So we'll get those going in a separate stream. And once that stream is live, we will announce it. Even if it's just like a 1 minute episode of me saying so, we will release it on this stream so you know where to find it. So when that's ready, you will know.
Yep, so it sounds good.
All right, I think that's all we got for this time. We'll see you next time.
Lauren, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. podcast was produced and recorded in St. Louis, Missouri.